Nous sommes en audience publique, Monsieur le Président.
Mr. President, we're in public session.
Now, Mr. Witness, just to be clear on this issue, you said it seems they were blaming Kikuyus for having taken all the jobs. Who was blaming the Kikuyus for having taken the jobs?
Those calling in, and later Mr. Sang will conclude so in his program.
When you say that Mr. Sang would conclude so, what would he do exactly? What would he say?
That was his norm. He will always make a conclusion after the program, and conclusion will always be in tandem with what the callers have said.
Are you able to recall, in regards to this whole question of the Kikuyus having taken all the jobs, what he would have said in general?
No.
You said that Mr. Sang would have been in tandem with what the callers would have said. Is that correct?
Yes, Your Honor.
Now, when you're saying in tandem, do you mean that he would have been supporting what the callers have stated?
Yes, Your Honor. In agreement.
Now, can you tell us during this period of time, prior to the post-election violence, what else were callers saying when they would call in to Len Emet show?
Apart from the issues that I've just said, that issues of protecting the land, issues of let's vote for ODM, let us vote against the constitutional document, apart from forging a common identity. I don't think I can remember other things.
Now, what would happen, Mr. Witness, when somebody would call in and give an opinion or a view which wasn't in line with ODM or wasn't supporting the ODM?
You would hear the tone of Mr. Sang change automatically. I think I had an experience. I once had an experience, somebody was calling in and you can hear the tone changing. That is not agreeing with that opinion. And sometimes it could be cut out.
Would there be any other consequences for people who would call in and disagree or express their disagreement with what Sang or the callers would be saying?
I once heard somebody saying that.
With your permission, Mr. President, may I object before the witness answers? Mr. President, you had overruled the hearsay, and the witness has introduced the intention of his answer, being that it is founded on what he was told. And I would pray that your injunction on hearsay do apply to this question.
Well, the witness is saying that he once heard somebody saying he's about to testify as to what he heard. Isn't that the case?
Yes, Mr. President, and that is the basis of my concern, that it is what he's going, or probably let him answer, Mr. President, then you will consider it.
Thank you.
I once heard somebody saying that a caller made once called KAS FM in this program and gave out a contrary opinion to the opinion that many held. And, you know, it was said that Sang...
President, first of all, may I apologize to the witness for having to interrupt his answer, with due respect. But it is very well fitting into the concern I had about TSA, Mr. President.
Your Honor, if I may, I understand that the Chamber made a ruling in regards to specific parts of this witness's testimony, but I think that we should first of all listen to what the witness has to say and listen to what is the basis for, even if it is hearsay evidence, and not prohibit it outright. I think that in the end it's a question as to what weight that the Chamber can accord this, but this is extremely relevant information for the prosecution. So obviously what my submissions are is that we should let the witness state exactly what the hearsay is, what information he is, and that eventually, when the rest of the evidence comes in and the record of the prosecution's case is closed, the Chamber can take a look at this record and listen and give the appropriate weight to the evidence that the witness is going to say. Hearsay evidence is admissible, and we shouldn't be prohibiting the prosecution from leading this evidence into the case, especially when it's quite relevant. I think it's a matter of weight in the end and not a question of admissibility. That's basically what I'm saying.
There are two things, Mr. Garcia. Hearsay is not always hearsay. If the witness said the witness listened to a program, that's a fact. And if that witness in listening to the program heard what was said in the program, that is a fact. The difficulty becomes whether a conclusion could be drawn as to that fact he heard with a view to achieving a certain juridical result in a case. That's a different consideration from saying, well, yes, because there's a charge that an accused person is facing, and at the end of it, the Chamber will make an evaluation, therefore all manner of hearsay can come in, and the Chamber at the end of it can disregard what it considers to not be weighted. There's a rule of probative value and also efficiency that goes into it. What's the point of receiving a host of hearsay if we don't use it for a certain purpose? But that's not what we're talking about here. The witness is testifying as to what he heard, said. We're now being urged at this stage to base finding on the basis of that, which is different from the other type of hearsay. So the witness can proceed with his answer.
Can I just put in, I hope
Yes.
it's useful to Pennyworth here, if one looks back to what the witness had said, which I think concerned my friend Mr. Catwell, it was to the effect, not that he heard someone say on the radio, but that he was saying, I heard someone who'd been listening to the radio heard this. In other words, it is hearsay. So if we go back to his original answer, which particularly in the context we're in, which is, of course, is what he heard himself on the radio, we see at line 15 at page 40, I once heard somebody saying that a caller made once call KAS FM in this program. So it's not a hearing with his own ears, it's related hearsay. And given the nature of the evidence, I would submit that that would fall into an area of, well, at very least, very little weight, and certainly not evidence of what this witness himself heard in respect of KAS FM, which of course is the element we're looking for.
That is my, hold on, that's what I seem to have heard, that he was listening and he heard somebody being cut out. Now, I see what you say with the transcript now looking back at it, but without looking at the transcript, as I was listening to it, it seemed to me that he said he was listening and had somebody. Maybe we have that cleared up.
May I say something before that question is? Mr. President, may I request that notice be taken of the fact that the prosecution themselves confirm or at least admit that that's hearsay. My learned friend's submissions were that yes, it is hearsay, but the way to be tied to it that the witness.
Mr. Kigen-Katwa, let's not debate that point. Let's have him clear up. Is he talking about what he had or what he had somebody say about the program?
Now, Mr. Witness, you've heard the discussion. What I'd like to know is, did you hear this personally on the radio, or did you hear somebody else who told you about this?
I heard from somebody else, not exactly from the radio.
So you've heard it from somebody else, and that person had heard it on the radio, or how did it happen exactly?
The person was giving a story that there is a caller who went contrary to what Mr. Sang wanted, and Mr. Sang said over the radio that look for that person and punish him for contributing to the radio what is not liked.
So you did not hear the thing yourself directly. That's what you're telling us.
Yes, Your Honor.
Prosecutor, that now puts us in a different zone of the matter.
I understand, Your Honor, and the comments that I had made initially, I thought that's what I heard. I understand the Chamber had heard otherwise, and now it's clear. But my comments and my arguments still stand. I think that hearsay is an important evidence, and it shouldn't be judged in the abstract. We don't have the whole case record for the prosecution yet. This is one of our first witnesses, and when the court is going to weigh this evidence, the hearsay evidence, it needs to look at other witnesses who will come and testify. And this type of evidence goes to a certain modus operandi that was used by Mr. Joshua Sang during his show. It's a type of pattern evidence. So it can't be judged. I think it's quite premature at this point to say that we should exclude it without considering other evidence that will eventually be led by the prosecution.
The Chamber's ruling is this. Again, we need to be very careful. There's a rule of efficiency that we must all keep in mind. It is one thing to say that the statute does not strictly prohibit hearsay, and we know that. The difficulty is where there's too much hearsay in the witness's testimony, which everyone knows that will not be given a lot of weight in the end. As we indicated before, we need to be cautious about what we call, well, in some places, bolstering evidence, which is there is a witness that has a direct eyewitness account to the fact and issue, and it may be only one such witness. But then, in the end, we've had so many hearsay evidence around it that gives that particular one witness extra weight than it deserves. That is the balance that we must strike. Prosecutor, you can proceed, but keep this in view. You will not be allowed to keep on leading hearsay evidence to saturate the record with it. That's all.
Grateful, Your Honor. And just for the record, it is not the prosecution's intent to buttress or bolster the evidence or the credibility of any other witness. This evidence is very...
Let's not argue the point. Just proceed. Thanks.
Now, Mr. Witness, you've just indicated to us one incident that you learned of. Was there any other incident that you learned out of this same type? People disagreeing with Mr. Sang?
There is person number 20 whom I met one morning, and he was saying that he has had altercation with Mr. Sang, and he was not happy that the way Mr. Sang is running his show.
Can you tell us when this, when you spoke to this person, number 20?
Later on, after death, after post-election violence.
And can you explain to us what this altercation was about?
He said something akin that he gave a contrary opinion, and Mr. Sang didn't like it.
My objection, Mr. President, was to the extent to which it is outside the scope of the charges, Mr. President. The witness has said it is long after, and I was wondering whether it's of any relevance or of any use to allow that testimony into record.
Prosecutor?
Your Honor, the prosecution is allowed to lead evidence, even if it is outside of the temporal scope of the charges, that would prove what happened during the temporal scope. And that's why I'm eliciting this evidence, because it goes to the modus operandi of how Mr. Joshua Sang handled his show and conducted his show. So the fact, obviously, and this is one of the points, is the fact that anyone who did call during the show and expressed opinions which differed with the party line, the ODM party line, were either cut off, as the witness has stated, or there would be consequences as well. And this is quite important to the charges against both the accused and especially Mr. Sang.
Proceed.
Now, Mr. Witness, can you, I think I asked you the question about what was the nature of the altercation. And I think you stated that there was a disagreement between this person and Mr. Sang. Is that correct?
To the effect that he seemed to have given a contrary opinion that Mr. Sang didn't like.
Now, Mr. Witness, what was this contrary opinion that this person gave that Mr. Sang didn't like?
I don't remember.
Now, do you remember having given this information before? Do you remember this information? Is it just now that you're forgetting, or have you given this information in the past to the prosecution?
I gave out this information. That is why the name number 20 appear here.
I just want to make sure, Mr. Witness, you're saying that you don't remember right now exactly what the altercation would have been about. Would you have remembered back at the time when you gave a statement to the prosecution?
I remember to have given the statement, but I thought it is to that effect. Number 20 gave a contrary opinion, and he was not happy that Mr. Sang didn't receive him in the way he wanted, and he was complaining.
Do you remember on what subject matter this differing opinion was on? What was it about?
Politics, basically.
Okay, I understand it was about politics. Do you remember what specifically about politics? What was the contrary opinion about?
I don't remember.
Now, Mr. Witness, would you be able to remember more if you had a chance to read over what you stated to the prosecution in this regard, back when you met the prosecution?
Your Honour, I'm sorry to interrupt, but are we really at the bottom of the barrel now, with an application looming, it would seem, to refer to a previous statement about what someone said that was hearsay? Is this really where the prosecution have driven themselves to?
Mr. Garcia?
Your Honor, I understand that the witness gave this statement in 2012, and it often happens that people forget details. There is a possibility always of refreshing the witness's memory, if need be, in relation to one paragraph.
And Mr. Hooper is asking, do we need to embark upon that exercise for purposes of having the witness testify to a hearsay?
I understand the Chamber's concern. It is an important point for the prosecution.
Is Mr. Hooper's concern?
I'm sorry, yes.
You were rising, Mr. King Kaswa?
Yes, with your permission, Mr. President, I very much strongly object to the prosecution's attempt. Mr. President will recall that the witness has been asked, and he said he has a recollection that that was the extent of what he said, being that what was conveyed was a contrary opinion. And so this is not a case where memory is failing. Secondly, Mr. President, and much as Mr. Hooper said, it's an issue which I wish to raise, that what is being solicited for is actually hearsay. It is not what the witness knows firsthand. It is what he was told by somebody else. We would strongly object to that attempt, Mr. President.
Thank you. Prosecutor, proceed. Objections overruled.
If we could just go into private session, Your Honor.
We go to private session.